"Sir, you'll need to step back from the filing counter," the court clerk announced loudly across the crowded probate office, where I'd been trying to obtain copies of legal documents my son Brian had apparently filed without my knowledge. "Your family has explained that you're here about competency proceedings, and these matters require legal representation." 25 pairs of eyes turned toward me as I stood holding my driver's license and identification card, documents that should have been sufficient to access public court records. Other families dealing with similar proceedings stared with mixture of sympathy and discomfort, watching what appeared to be another confused elderly man struggling with legal procedures. "Dad, please don't make this more difficult than it needs to be," Brian said, approaching from the attorney consultation area where he'd been speaking with his lawyer, Marcus Webb. "We're just trying to protect you from making harmful decisions while your judgment is compromised." Behind the filing counter, 3 court officials observed the situation, while other families waited their turn for similar elderly protection proceedings. Several people were discreetly taking notes, probably learning about guardianship procedures for their own family situations. "He's been showing clear signs of cognitive decline for months," Brian explained to the gathering crowd, his voice carrying the practiced concern of someone who'd rehearsed this explanation. "Confusion about financial matters, difficulty understanding legal documents, inappropriate suspicion of family members trying to help him." I stayed quiet, gripping my wallet that contained credentials Brian had never seen. They mistook my silence for weakness. But Brian didn't know who I was. He didn't know that I'd spent 39 years as a constitutional law attorney and federal judicial advisor, specializing in civil rights and elder protection cases. He didn't know that I understood every legal strategy he was attempting, every procedural manipulation he was using to have me declared incompetent. And this didn't start today. It started 2 months ago when Brian began questioning my capacity to make sound decisions after I'd refused to sign documents transferring my property to him. But the real shock would come tomorrow at the competency hearing when I revealed exactly who he'd chosen to target. And that was only the beginning. I should have noticed the first sign 2 months earlier when Brian started bringing attorney Marcus Webb to our Sunday family dinners, always steering conversation toward my declining mental acuity and the need for proactive legal protection of my assets. "Dad, Marcus has been explaining how important it is for elderly people to have proper safeguards in place," Brian had said during one particularly manipulative dinner conversation. "People your age often develop impaired judgment without realizing." Webb had nodded professionally, pulling out legal documents that supposedly showed examples of elderly financial exploitation that could be prevented through appropriate legal oversight. The irony was lost on both of them. "Mr. Henry, your son is absolutely right to be concerned," Webb had explained, spreading official-looking paperwork across my dining room table. "Cognitive decline often affects financial decision-making first. Family members need legal authority to protect vulnerable elderly relatives." What I didn't realize at the time was that Brian and Webb were building a systematic case for having me declared legally incompetent while positioning themselves to gain control over everything I'd accumulated during 4 decades of legal practice. Brian had been documenting my supposed confusion about complex legal matters, claiming that I'd become paranoid about family members and suspicious of legitimate legal advice. He'd even arranged for a friendly doctor to conduct a routine wellness check that somehow became an unofficial competency evaluation. "The signs are unfortunately very common," Webb had told Brian within my hearing. "Resistance to accepting help, paranoid thoughts about family exploitation, inability to understand complex legal documents, classic patterns of age-related cognitive impairment." But Brian had made a fundamental miscalculation about his target. He'd seen a 74-year-old retired man living quietly since my wife Eleanor passed away 3 years ago, and assumed I lacked the legal expertise to recognize systematic competency manipulation. He had no idea that some quiet old men had spent their careers specializing in exactly the types of elder exploitation cases he was attempting to perpetrate against his own father. I should have noticed the first sign. The next morning brought clarity when I reviewed the competency petition Brian had filed, documentation that activated every legal instinct I'd developed during nearly 4 decades of constitutional law practice and elder rights advocacy. What Brian and Webb didn't know was that I wasn't just a retired attorney. I was Henry Rodriguez, former senior counsel for the American Civil Liberties Union and federal judicial advisor specializing in elder protection statutes. I'd spent my career defending vulnerable people against exactly the types of legal manipulation they were attempting. I'd worked on landmark cases involving family exploitation of elderly relatives, helped draft federal legislation protecting seniors from competency fraud, and served as expert witness in hundreds of cases involving systematic elder abuse through legal proceedings. But I'd retired quietly 6 years ago, choosing suburban anonymity after Eleanor's death, rather than maintaining my high-profile legal career. She'd been my anchor for 47 years, and without her, I'd felt disconnected from the legal community that had once defined my professional identity. Brian had seen my withdrawal from social activities and assumed that retirement meant I'd lost both my legal expertise and my connections within the judicial system. He'd researched my financial assets, but had never investigated my professional background or the extensive network of legal contacts I'd maintained. Eleanor had always been proud of my work protecting civil rights and fighting systematic discrimination. She'd kept newspaper clippings of major cases I'd won, framed photographs of Supreme Court arguments I'd presented, awards from legal organizations recognizing my advocacy for vulnerable populations. Brian was about to learn that targeting a retired constitutional law attorney who specialized in elder protection for competency fraud was the most expensive mistake of his legal career. But the real shock came later that morning when I began examining the specific legal strategies Brian and Webb were using to build their case against me. That morning felt heavier when I discovered the extent of Brian's systematic campaign to have me declared incompetent while positioning himself to control my $1.8 million estate and the house Eleanor and I had owned for 32 years. Brian had been secretly recording our conversations, photographing my daily activities, and creating detailed documentation of what he characterized as concerning behavioral patterns that supposedly indicated cognitive decline. He'd even enlisted my neighbors in gathering evidence of my confusion and forgetfulness. The documentation is quite comprehensive, I overheard Webb telling someone during a phone conversation. Witness statements about confusion, medical opinions about declining judgment, financial records showing concerning decisions. The court should grant emergency competency proceedings without difficulty. But Brian's case wasn't just about gaining legal authority over my assets. He'd been researching assisted living facilities that specialized in housing individuals with court-appointed guardians, planning to institutionalize me while liquidating everything Eleanor and I had built together. The target is the portfolio plus the property, Webb had written in an email I'd discovered through careful investigation. Full asset liquidation should be possible within 6 months of gaining guardianship authority. Ongoing care costs will be minimal compared to the estate value. What Brian was really targeting was my $1.8 million investment portfolio, the house Eleanor and I had spent 3 decades paying off, and my federal pension accumulated through decades of civil rights work. Combined with Eleanor's life insurance and our joint savings, he stood to control nearly $2.5 million in total assets. But Brian had made a catastrophic miscalculation about his target. He'd seen a quiet widower living alone and assumed I'd be vulnerable to sophisticated legal manipulation by attorneys who specialized in elder exploitation. He'd never considered that some retired lawyers had spent their entire careers fighting exactly these types of systematic attacks on elderly people's civil rights and legal autonomy. He had no idea who he was dealing with. But Brian made his critical mistake when he submitted psychological evaluations, claiming I'd been diagnosed with progressive dementia, using documentation from a doctor who'd never actually examined me for cognitive issues. The fraudulent medical evidence triggered verification procedures that exposed his entire scheme. The psychiatric report contains terminology and diagnostic codes that Dr. Martinez doesn't use in his practice, my investigator colleague Patricia explained, showing me detailed analysis of the forged documentation. More importantly, the evaluation dates don't match Dr. Martinez's appointment scheduling records. As a retired constitutional lawyer who'd specialized in civil rights violations, I recognized every technique Brian and Webb were using. Their competency fraud followed patterns I'd fought against for decades, but they'd made critical procedural errors that any experienced legal professional would immediately spot. "There's something else," Patricia continued, her voice filled with professional outrage. "The psychological evaluation was apparently conducted by someone using Dr. Martinez's letterhead without his knowledge or consent. That's not just competency fraud, it's medical identity theft." The level of premeditation was staggering. Brian had spent months building a false case for my incompetence while creating fraudulent medical documentation to support expedited guardianship proceedings. He'd researched elder law extensively, but had made legal errors that would be obvious to any competent judge. "I've also discovered that Webb has been advising Brian on asset liquidation procedures before the competency hearing has even occurred," Patricia explained. "They're planning to begin selling your property immediately after gaining guardianship authority." Brian had left a legal trail that any competent court would follow directly to criminal charges. His business background had given him understanding of financial procedures, but he'd forgotten that competency cases involving retired federal employees receive enhanced judicial scrutiny. He was about to learn that attempting competency fraud against a retired constitutional lawyer was the most expensive mistake of his criminal career. That mistake cost him everything, and I knew the trap was closing around Brian when Patricia introduced me to Detective Morrison from the Elder Abuse Division and Attorney Williams from the State Attorney General's office. The investigation had expanded rapidly once court officials noticed irregularities in Brian's expedited competency petition. "Mr. Henry, we've discovered that your son has created an extensive criminal enterprise focused on gaining fraudulent control over your estate through manipulated competency proceedings," Detective Morrison explained. "Forged medical evaluations, false witness statements, and systematic documentation designed to support fraudulent incompetence claims. The evidence was overwhelming and sophisticated." Brian had enlisted Webb's legal expertise in creating a comprehensive fraud scheme that targeted not just my assets, but my fundamental civil rights and legal autonomy. We've also found correspondence between Brian and assisted living facilities that specialize in housing individuals with court-appointed guardians, Attorney Williams added. "The plan appears to have been systematic institutionalization while liquidating your entire estate under guardianship authority." Patricia spread additional evidence across her desk. Screenshots of Brian's financial planning documents, emails with asset liquidation specialists, correspondence with facilities that advertised secure care for legally incompetent elderly residents. His plan was remarkably detailed, Detective Morrison noted. File fraudulent competency petition, gain emergency guardianship through forged medical evidence, institutionalize you immediately, and begin systematic asset liquidation within weeks. But what Brian didn't understand was that he'd targeted someone with intimate knowledge of exactly these types of civil rights violations. I'd fought similar cases for decades, understood every legal technique he was using, recognized every pattern in his fraudulent behavior. The investigation had also revealed that Webb's law firm had been researching competency procedures for other elderly clients, suggesting a broader pattern of systematic elder exploitation that extended far beyond my case. The trap was almost ready. That evening felt surreal when Brian called to prepare me emotionally for tomorrow's competency hearing, his voice carrying the same caring concern he'd used for months while systematically planning to destroy my independence and steal my life's work. "Dad, I want you to know that tomorrow's hearing is really for your own protection. The judge just needs to ensure you're safe from making decisions that could harm your financial security." I could hear the confidence in his voice. Brian was probably reviewing his final preparations with Webb, calculating how quickly they could gain legal control once the court granted guardianship authority over my affairs. "Actually, Brian, I've been having some very interesting conversations recently," I replied calmly. "With investigators, with attorneys from the State Attorney General's office, with colleagues from my former practice." There was a long pause before he responded, and I could practically hear his mental gears shifting as he tried to assess whether his competency fraud had been detected by law enforcement. "Dad, what kind of colleagues? You've been retired for years. The kind who specialize in civil rights violations, elder exploitation, and fraudulent competency proceedings. They seemed very interested in your petition and the medical documentation Webb helped you submit." Brian's breathing had become rapid and shallow. He was realizing that his months of criminal planning had been completely uncovered by investigators who understood elder law far better than he did. "Dad, I think you're confused about what's happening," Brian said desperately. "The competency hearing is designed to protect you from exactly this kind of paranoid thinking. Maybe Webb and I should come over so we can explain the process more clearly." But his voice was shaking now. Brian understood that his criminal enterprise was collapsing, that tomorrow's hearing would expose his fraud rather than validate his claims about my supposed incompetence. He was losing control. That night, the calm before Brian's courtroom destruction felt heavy with disappointment in my son and rage at his calculated betrayal of everything Eleanor and I had tried to teach him about justice, dignity, and protecting vulnerable people rather than exploiting them. I sat in the study where Eleanor and I had spent countless evenings discussing legal cases, reviewing the comprehensive evidence file the investigators had assembled about Brian's systematic fraud. The investigation had revealed that Brian's scheme was even more extensive than initially discovered. Over 8 months, he'd created false documentation, enlisted multiple accomplices, and built infrastructure for liquidating my entire estate while maintaining guardianship authority indefinitely. "Mr. Henry," Detective Morrison had explained during our final briefing, "your son's computer contains detailed research into secured memory care facilities in remote locations, far from anyone who might question his guardianship decisions or advocate for your legal rights." The evidence painted a picture of calculated cruelty that went beyond simple financial theft. Brian had been planning to destroy my life completely, steal my assets, sell my house, have me declared legally incompetent, and warehouse me in institutional care where I'd never be able to expose his crimes or maintain Eleanor's memory. I thought about Eleanor, who'd been so proud of my civil rights work, my dedication to protecting vulnerable people from exactly the types of systematic exploitation Brian was attempting. She'd believed we'd raised a son who understood justice and human dignity. Tomorrow morning, Brian would discover in open court that he'd targeted not just any elderly man, but someone whose entire legal career had been devoted to fighting the exact crimes he was attempting to commit. Tomorrow, everything would change forever. But the confrontation came quietly when Brian and Webb entered the courtroom for what they believed would be a routine competency hearing that would grant them legal control over my life and assets. Their confidence was obvious as they approached the petitioner's table, probably calculating how quickly they could begin asset liquidation. "Your Honor, we're here seeking emergency guardianship for my father, who has been exhibiting clear signs of cognitive impairment that make him vulnerable to exploitation," Brian told the judge, consulting his carefully prepared notes while Webb organized their fraudulent documentation. The courtroom was filled with other families dealing with legitimate guardianship proceedings, and Brian had positioned himself as the concerned son, protecting his vulnerable father from his own declining judgment. "The medical evidence clearly indicates progressive cognitive decline that affects my father's ability to make sound financial and legal decisions," Webb added, presenting the forged psychological evaluation to the court. "We're requesting immediate guardianship authority to protect his assets and ensure appropriate care." I looked at them calmly from the respondents' table, where I sat without legal representation because I'd chosen to represent myself, something that had puzzled both Brian and Webb. "Your Honor," I said, rising to address the court, "before you consider this petition, I'd like to present some evidence about the fraudulent documentation that's been submitted, and I'd like the court to understand exactly who the petitioners have chosen to target for competency fraud." I walked to the evidence table and began laying out documents that Patricia and I had prepared. Proof of forged medical records, evidence of systematic documentation fraud, and most importantly, my professional credentials that Brian had never bothered to investigate. "Your Honor, I am Henry Rodriguez, former senior counsel for the American Civil Liberties Union, federal judicial advisor specializing in elder protection statutes, and author of 3 landmark Supreme Court cases involving civil rights violations against vulnerable populations." The courtroom went completely silent. Brian's face went from confident to horrified as he began to understand the magnitude of his miscalculation. I simply folded my hands and smiled quietly at my son. "Your Honor, The petitioners have attempted to perpetrate competency fraud against someone who spent 39 years fighting exactly these types of civil rights violations. He realized what I truly was, and justice came quietly that afternoon when court officers arrested Brian and Webb on multiple felony charges related to their elaborate competency fraud scheme. The judge had immediately halted proceedings and contacted law enforcement once I'd presented evidence of their systematic criminal behavior. Brian Rodriguez and Marcus Webb are being charged with elder abuse, conspiracy to commit fraud, filing false documents with the court, and violating federal civil rights statutes, Detective Morrison explained. They're facing 15 to 20 years in federal prison. The asset forfeiture proceedings had frozen both Brian's personal accounts and Webb's law firm's client trust funds pending investigation. The inquiry had revealed that they'd been researching similar schemes involving other elderly clients, suggesting a pattern of systematic elder exploitation. Webb's law license was suspended immediately, and the State Bar Association launched an investigation into his practice that would likely result in permanent disbarment. His legal career was effectively over. The hardest part was explaining to my grandchildren that they wouldn't see their father for 15 years, that the college funds Eleanor and I had established for them were safe only because we'd caught Brian before he could liquidate them through fraudulent guardianship authority. 6 months later, I accepted an invitation to address a national conference on elder law reform, using Brian's case as an example of how sophisticated criminals exploit competency proceedings to victimize elderly people. Eleanor would have been proud that I'd used this terrible experience to strengthen protections for other vulnerable seniors. The federal charges ensured that Brian would spend most of his remaining productive years in environments where his manipulation skills would prove entirely ineffective. Other elderly victims would be protected from his predatory behavior. Sometimes the quietest revenge is simply allowing the justice system to function exactly as it was designed. Brian had calculated that an elderly widower would be easy prey for sophisticated competency fraud, even when that widower happened to be a retired constitutional lawyer who specialized in civil rights protection. He'd learned too late that legal expertise doesn't disappear with retirement, and that some fathers carry decades of courtroom experience that turn family betrayal into federal prison sentences and professional disgrace. But justice in federal court stays silent, patient, and inevitable, as Eleanor's memory guiding every decision.